Republic Act 11362 or the Community Service Act. Congress passed RA 11362 or the Community Service Act, which was signed into law by President Duterte on August 8, 2019. The said Republic Act authorizes the court in its discretion to require community service in lieu of imprisonment for minor offenses. It is the policy of the state to promote restorative justice and decongest jails by authorizing the court in its discretion to require community service in lieu of service in jail for offenses punishable by arresto menor and arresto mayor. Under the revised penal code, the duration of the penalty for arresto mayor is imprisonment of 1 month and 1 day to 6 months, while arresto menor has a duration of 1 day to 30 days imprisonment. This is based on Article 27 of the revised penal code or Act 3815. Offenses punishable by arresto mayor and menor of the following includes alarms and scandal, malicious mischief, offending religious feelings, unjust vexation, using false certificates, and slight physical injuries, and among others. If proven to be true, any crime should be given the proper punishment, such as incarceration, with circumstances in consideration. Sometimes, however, the act of imprisoning someone may prove to be detrimental to the person's well-being or may even encourage more criminal behavior. Community service as a sentence would involve any physical activity that encourages civic consciousness and is for a public work or service, and according to the guidelines approved by the Supreme Court, community service should be subject to specific terms and must consider the gravity of the offense. Community service shall consist of any actual physical activity which inculcates civic consciousness as means intended towards the improvement of a public work or promotion of a public service. And take note, this privilege may be availed of only once. Community service as a penalty is not a new concept. It is part of what is called restorative justice, where the offenders are sentenced to repair the harm done to people, relationships, and communities. It is expected that with the enactment of this law, the state's policy to promote restorative justice and to decongest jails will be achieved, apart from the law's objective to improve public work participation and promote public service. Here are the guidelines for community service. It must be served in the place where the crime was committed. The number of hours ordered by the courts must be completed within the period likewise prescribed by the courts. The person sentenced must undergo rehabilitative counseling under the Social Welfare and Development Officer of the city or municipality where the crime was committed. And the person rendering community service must be under the supervision of a probation officer. Application for community service. How do you apply? It must be filed within the period to perfect an appeal, and said application shall be resolved within 5 days from filing thereof. So after the application, the court shall immediately notify the barangay chairperson or authorized representative of the barangay where the crime was committed. They should also notify the representative from the provincial or city's probation officer, and they should notify the local government unit's social welfare development officer. The court may resort to electronic service of the notices to the said officers. The court shall resolve the application for community service immediately after the hearing thereon. An order granting or denying the same shall not be appealable. Failure of the accused to appear at the said hearing, except for a justified reasons, shall be a ground to deny the application, and a warrant of arrest shall be issued against the accused. If a convict violates the terms of the community service, he shall serve the full term of his penalty in jail or be placed on house arrest if the penalty is ARRESTO MENOR. Conversely, if he completes the terms of the community service, the court shall order his release unless detained for another offense.
Basically, here are factors that are considered in the exercise of imposing community service. The court must consider the following two. The term must be commensurate with the gravity of the offense and the circumstances of the case, meaning the term shall be proportional to the offense made. Thus, since the ARRESTO MAYOR is a penalty higher than the ARRESTO MENOR, it implies that the term of the community service is heavier, the ARRESTO MAYOR, than that of ARRESTO MENOR. The welfare that the service will bring to society. It means that community service when imposed shall promote the well-being of the community, that the community will benefit from such penalty. And lastly, the reasonable probability that the person sentenced shall not violate the law while rendering the service. The courts shall consider the possibility that the accused might violate the law, that the community service, instead of becoming a medium to penalize, it become a breach of another crime or offense by rendering the service. What are the effects if the convict violates the term of the community service? First, the convict will serve the full term of his penalty in jail, or the convict shall place in house arrest if the penalty is ARRESTO MENOR. How about if the convict completes the term of the community service smoothly? Here, the court shall order his release unless, of course, he is detained again for another offense. And that's all for my report. Thank you.